Your Honor, this is Doug. I just want to let you know I'm here, even though my picture's not there.
Good morning, Doug. Thank you. Good morning, everybody. Are we on the record, Doug?
We're on the record, Your Honor.
Great, thank you. Good morning. Today is September 14th, 2021. It's approximately 10 a.m. My name is Christine Burke. I'm a public utility law judge with the Maryland Public Service Commission. We're here this morning in case number 9664, titled in the matter of the application of Columbia Gas of Maryland, Inc. for authority to increase rates and charges. If I could, today's hearing is being recorded and also being live streamed on the Public Utility Law Judge's YouTube channel. If I can start with the appearances of the parties, please, beginning with the company.
Good morning, Your Honor, and good morning, everyone. Carville Collins for Columbia Gas of Maryland.
Good morning.
Good morning, Your Honor. This is Megan Moore on behalf of Columbia Gas of Maryland.
Good morning.
Good morning, Your Honor. Amy Fracas on behalf of Columbia Gas of Maryland.
Good morning. And for OPC?
Good morning, Your Honor. Joe Cleaver on behalf of the Office of People's Counsel, and I'm here with Daria Pugh. Thank you.
Good morning. And staff.
Good morning, Your Honor. Annette Garofalo on behalf of Commission staff. With me is Kenneth Albert and Catherine Bachelar.
Good morning. We left off yesterday, I believe, with Columbia witness Ray scheduled to begin today. Are there any preliminary matters before we begin?
Your Honor, staff has one preliminary matter. It has to do with the transcript. I had received a call this morning regarding the transcript. It appeared to the person calling me that only the transcript before lunch was available. I just wanted to make sure that there was not an issue with that.
The transcript as far as the broadcast on YouTube, or
the transcript from the court reporter for the hearing yesterday appeared to the person calling me, I've not checked it myself, to not be fully available. I just wanted to see if there was an issue, and I don't know if there's anything we can do to resolve it, but wanted to bring that to your attention.
Your Honor, these are not live notes, so yes, it takes a little time to get the transcript available.
I apologize, Doug, I couldn't hear you, but I think you said it's not available yet, but would be. Is that correct?
That is correct. Is there a rush on this one? Can you tell me about that, Annette?
Staff never puts in a rush request. No, the person was not at the hearing and wanted to see what had been said.
They can see it on YouTube, but the actual written transcript takes several days.
Okay, thank you.
Thank you for asking. That's very nice of you to ask. Thank you.
are there any other preliminary matters?
Yes,
Hi,
Your Honor.
Your Honor, Columbia can go ahead. We'll wait.
Yes, just one preliminary matter from Columbia. I'm going to let my co-counsel, Ms. Moore, address that.
Thank you, Mr. Collins. Yesterday evening, I emailed to the parties and Your Honor a few more Columbia exhibits, one of which I labeled Columbia Hearing Exhibit 16. Columbia discussed with staff and also let OPC know that it would be offering this revised exhibit into the record. Yesterday, when Mr. Racher was testifying, he mistakenly thought that this exhibit was actually part of the record already, but it was just a work paper that had been provided to staff via email. So in discussions with staff asked that we ask Your Honor if we could enter this exhibit into the record. And I also wanted to note that Mr. Racher is here if either party has a question about the exhibit. So the company would ask that the revised Exhibit 3, Sheet 7 work paper be marked as Columbia Exhibit 16.
So marked. I did receive a copy of this yesterday. Is there any objection from OPC as to the admission of this? Indicating no. And from staff, I'm assuming since
No objection.
okay, thank you. So this will be admitted as Columbia's Exhibit 16 to the record.
Thank you, Your Honor.
And I don't have any other questions for Mr. Racher. If you need to excuse him today, that would be fine, unless anyone else has any objection to that.
No,
Yeah, don't. Let me
no, I'm just cruising out.
No objection, Your Honor.
Okay.
Very well then. Your Honor, we will excuse Mr. Racher with our thanks, and we are prepared to call Mr. Ray when Your Honor is ready,
You're-
unless LPC has a preliminary matter.
A couple preliminary matters, Your Honor. Thank you. Good morning.
Good morning.
The first preliminary matter, just consistent with the conversation between counsel and the bench yesterday, we filed updated schedules for OPC witness Lafayette Morgan this morning, and they were served on the parties, and I believe Your Honor was copied on that. Mr. Morgan will be prepared to answer any questions on the stand today about those changes and can explain the changes that were made. The ultimate outcome of the changes, Mr. Morgan's determined revenue deficiency for the company has actually increased from about 192,000 to around 280,000. The precise numbers are reflected in the schedules, and Mr. Morgan can explain why when he takes the stand. But I wanted to make sure the record was correct, and it's a change, of course, to the company's benefit. So Mr. Morgan will explain all of that, the different changes he made and why. The second preliminary matter, Your Honor, just a question for planning purposes within our agency for tomorrow. Are we starting at 10 o'clock, or does Your Honor plan to start later to allow parties to attend the administrative meeting?
We can start later.
Okay. I think
As long as that does not pose a problem for the court reporter. Doug, are you will that cause any scheduling issue for you for tomorrow?
I can work around it. What's it look like? It starts at 10 a.m. again?
the admin meeting starts at 10, Doug, and there's only one matter on the administrative item. It's actually a matter directly relevant to this case. It's BGE's proposed tax rider. I think there's a couple items, maybe two. I haven't looked since Friday on the consent agenda, and then there's one item on the admin agenda. Probably will take a little bit of time on that tax matter for the commission, but it looks like a relatively short agenda.
Would 11:30 be an appropriate time to start? Would that give everybody enough time?
That sounds like more than enough time. That's acceptable to OPC. Thank you, Your Honor.
Is that acceptable to the other parties?
That's acceptable to staff, Your Honor.
Acceptable to the company. Thank you.
Yeah, so tomorrow we can start at 11:30 then, and I will send out a revised invitation for WebEx so that it's clear we're starting at 11:30. It'll have a separate invitation.
Okay, thank you. And then the third item, Your Honor, I sincerely apologize. We're having a technical issue. That's why our IT specialist is sitting next to me. We're having a problem with our sound. I wonder if we may just have a few minutes of your indulgence to try to resolve this problem that has cropped up this morning.
That's fine.
Apologize. So we're gonna, I think, leave the hearing. We'll be back momentarily. Thank you.
We'll take a brief recess then. Thank you.
Thank you.
And if you might still be in it.
Yeah, I think we might still be in it, June.
Yeah.
Well, can you just mute, if we're gonna stay in it, can you mute us, or I just don't want them to hear us. If you go back to the Chrome
Yeah.
button.
Let's see. All those, you're still in it. You signed in with the laptop or with the desktop?
With both, but that you saw there was through the desktop. This I'm just using for my trial.
Oh, okay.
So this is not a part of our, that's not a part of our participation in the hearing.
Okay.
Joe, can you mute, please?
Go to Chrome, open the Chrome browser.
Okay.
If you just open right here,
There we go.
if you open here, and there's like another window.
I can't see it for that. All right. Sorry. Close this. Open this.
And just mute it there, bottom left.
There it is. Okay.
in line glide.
That we can work with.
Your Honor, we're back on and everything's been fixed.
I can hear you now. Great.
Thank you, and again, apologize for that. Appreciate your indulgence. Thank you.
Certainly. Is everybody else here?
Hold on one second, Your Honor. Okay, you're on the record now.
Okay, thank you, Doug. We're back on the record in the matter of the application of Columbia Gas of Maryland, Inc. for authority to increase rates and charges, case number 9664 with the Maryland Public Service Commission. Counsel for Columbia, are you ready to proceed with your witness?
Yes, we are, Your Honor. I just want to confirm that our witness is with us, Mr. Ray. I think I see him, yes.
Good morning.
So yes, we are ready to proceed if you are.
Yes, please. Thank you. Mr. Ray, could you please raise your right hand? Do you swear or affirm under the penalties of perjury that the testimony you're about to give is the truth?
I do.
Thank you.
Morning, Mr. Ray, and thank you for joining us. Are you able to hear me okay?
I can hear you just fine.
Thank you. For the record, Mr. Ray, please state your employer and title.
Employer is Regulatory Finance Associates, LLC, and my title is Managing Director.
And do you have before you your testimony in this matter consisting of the following? Your direct testimony dated May 14th, 2021, together with exhibits VVR 1 through VVR 12. Also, appendices A through D, Exhibit 10, and Supplemental Exhibit 10, together with your rebuttal testimony, including Exhibit VVR-1R and Rebuttal Exhibit 10, and finally, Surrebuttal Exhibit 10.
Yes, I have each of those documents here.
And was this testimony prepared by you or under your supervision?
Yes, it was.
Do you have any changes, corrections, or updates to your testimony?
No, I do not.
Is your testimony true and accurate to the best of your information, knowledge, and belief?
It is.
If you were giving this same testimony today, would it be the same as when the testimony was originally filed?
Would.
And Your Honor, I would ask that the testimony and exhibits of Mr. Ray be marked as Columbia Hearing Exhibit 12.
So marked.
And if there are no objections, I would ask that Columbia Hearing Exhibit 12 be admitted into the record.
Office of People's Counsel, any objection?
No objection, Your Honor.
As staff, any objection? I think you're muted. Can't hear you.
Sorry, Your Honor. I had that backwards there. Yeah, staff has no objection to Mr. Ray's testimony.
Thank you. Mr. Ray's testimony and exhibits that were listed by Mr. Collins will be admitted to the record as Columbia Hearing Exhibit 12.
Thank you, Your Honor. Your Honor and parties, we have a brief live rejoinder with Mr. Ray.
Okay. Please proceed.
Mr. Ray, I wonder if I might ask you to refer to page 2 of Staff Witness Kirkendall's surrebuttal testimony. Do you have it?
Give me just a moment, please. You said surrebuttal testimony?
Surrebuttal testimony of Staff Witness Olivia Kirkendall.
Okay, I've got it.
And that's page 2.
Okay.
Ms. Kirkendall notes in her rebuttal testimony, beginning on line 9 of page 2, that, quote, "The ROEs awarded by the commission serve as reasonable benchmarks when considering the fair return on equity to be awarded to a utility," end of quote. Do you see that line?
Yes, I do.
Do you agree with this statement, and why?
I would respond that they are reasonable benchmarks primarily because they represent the balancing of interest between the company's customers and the company's shareholders. In recent years, obviously, there's been both settled and litigated proceedings. And so, yes, I think I would agree with this statement that, again, they represent a balancing of interest between stakeholders, the utility stakeholders. And I guess along those lines, I think I would point out that in recent years, there's been a couple of outcomes that we do believe are reasonable benchmarks based again upon balancing of interest. And that would be the case from WGL from just 4 or 5 months ago. And in that case, that was a fully litigated proceeding. The commission authorized an ROE for WGL of 9.7%. And WGL's capital structure, by and large, was equivalent to Columbia's capital structure in this proceeding. Aside from that, I would also point out that the risk of Columbia of Maryland, very different than the risk of Washington Gas Light from the standpoint that Columbia of Maryland is a very small utility with 33,000 customers. I believe WGL has upwards of 500,000 customers, so I would say that Columbia of Maryland is about 1/15 the size. So to the extent that we are viewing these as reasonable benchmarks consistent with Ms. Kirkendall's testimony, what I would argue is that 9.7% outcome for WGL, I think, is a reasonable benchmark as it represents the balancing of interest. But I would also point out as a caveat that the two companies do have a different risk profile. Columbia is a much smaller entity. It's roughly 1/15 the size. The same is true of a recent outcome in Maryland with regard to BG&E. I think that outcome was back in December or January, so maybe 9 or 10 months ago. That outcome was at 965. Again, is that a reasonable benchmark? Yes, it represents the balancing of interest. But again, BG&E is a significantly larger company than Columbia of Maryland. I think BG&E has upwards of 700,000 customers, so about 21 times the size of Columbia of Maryland. For that reason, I would say these are reasonable benchmarks. But when you consider Columbia is a much smaller entity and therefore has a higher risk profile, which would merit a higher cost of equity.
Thank you, Mr. Ray. No further questions on live rejoinder. So, Your Honor, the witness is available for cross-examination or questions from Your Honor.
Thank you. OPC, do you have cross-examination?
Thank you. Good morning, Mr. Ray. My name is Daria Pugh, and I just have a handful of questions for you today.
Good morning.
So first, Columbia Gas is a subsidiary of NiSource and is not a publicly traded company, correct?
That is correct.
And in other words, Columbia Gas does not issue its own stock, correct?
I just want to make sure I understood. Columbia of Maryland does not issue its own stock. Is that the question?
Yes.
I would just respond by saying that Columbia of Maryland does issue stock, but just not in the public capital markets. They do issue stock to their immediate parent company. Just there's a slight nuance there that I think is important to note.
But an investor can't own stock.
I'm sorry, was there a question?
And so when a regulator is attempting to determine the appropriate ROE for Columbia, it must estimate the equity cost based on the market data and other financial information, correct?
Yes, because Columbia of Maryland is not publicly traded, we rely upon proxy group analyses that provide market data in order to estimate cost of equity for Columbia of Maryland.
Thank you. And isn't it true that when a regulator awards an ROE to a distribution utility that is not publicly traded, it bases the ROE on several factors, including returns from proxy groups, like you mentioned, composed of companies of similar risk profiles?
I'm sorry, I heard some beeping of folks joining. Can you just repeat the last part of that question? I couldn't quite hear that.
Sure, no problem. So the regulators, when they're determining a distribution utility company's ROE that's not publicly traded, it bases the ROE on several factors, including returns from proxy groups composed of companies of similar risk profiles.
I agree with that, with the caveat that there's another step in the process, and that is that we cannot automatically assume that the proxy groups have an identical risk profile to the subject utility. There are many circumstances, particularly in the instant proceeding, where the risk profile of the subject utility, as proven by verifiable and objective risk measures, can be different than that of the proxy group company, and that is certainly the case in the instant proceeding.
And as you discussed in your testimony, you used proxy groups to arrive at your recommended cost of equity in this case, correct?
Yes, that's correct. And specifically, we referenced 3 different proxy groups because we want to ensure that we have as robust an analysis as possible. That's why we also look at combination gas and electric utilities. We place less weight on it. And we also look at non-regulated entities only because we want to understand what the competitive market result is per the dictates of Hope and Bluefield. So I would argue that to the extent that we're only focused on a small gas proxy group, you don't have a level of statistical reliability that is indicated to do a robust analysis, particularly since in recent years, a lot of the gas utility holding companies have been acquired by electric utility holding companies. So the number of candidates for proxy group inclusion has been shrinking over the years. So again, I think it's important to have as robust analysis as possible by expanding the proxy group to the extent that you could prove by verifiable measures that you have entities that represent corresponding risk as per Hope and Bluefield.
Thank you.
Hold on 1 second. Mr. Ray, could you sort of lean into the computer when you speak because you fade in and out? And
Okay. I will also adjust my volume.
That's better.
Is that better?
I can hear you a little better.
And Ms. Pugh, the same thing, you fade out too.
Okay. Okay, and so for the proxy groups that you mentioned, are the companies in those groups publicly traded?
Yes, they are.
And so that means for your chosen proxy companies, you have actual market data that you used, including data on actual returns to develop predicted returns for those companies, correct?
I'm not sure I would characterize it exactly that way when you say actual returns, because it's not like we are looking at historical book returns. Because we're using market-based analytical models, we're basically employing those models, coming up with the expected cost of equity or the market required cost of equity. So I wouldn't say actual. I don't know if you're characterizing it as actual returns, but we're certainly not looking at book returns because we're developing the market-based cost of equity.
But you do incorporate historic data from those proxy groups in your analysis, correct?
You know, I'm going to have to ask if I would appreciate if maybe you could be a little bit more specific, because I don't know that we're looking at historical data on a company specific basis. We are looking at historical data when we come up, for instance, in the capital asset pricing model with our market risk premium. There we present a balanced approach in determining the market risk premium, where we look at both historical returns, historical risk premiums, and then we couple that with prospectively or forward-looking based risk premiums in that. So if I could just ask you to clarify which part of the analysis you're speaking to, I would appreciate that.
Yes, I was just trying to confirm that historical returns do factor into your analysis.
I think that's a fair statement, but not in the context of looking at those returns from an individual proxy group company standpoint. As it relates to understanding market returns, yes, I would agree with your premise.
Okay, thank you. And the market data and return data for the companies in your proxy groups would reflect the actual cost of those companies incurred from issuing stock, correct?
No, I would not agree with that. And the reason why you're talking about stock issuance cost, I would assume.
Yes.
Okay. No, the reason why I would disagree with that is because in the market-based cost of equity models, there's an underlying presumption in all of those models that there are no transaction costs involved in applying the analytical models. So, you know, those are key underlying assumptions of the DCF, the CAPM, and to a lesser extent, the risk premium model, that in all of those so-called theoretical models, there were no transaction costs assumed. So there's really no mechanism by which you could argue that by applying the cost of equity models, you've incorporated flotation costs. And that's why we apply a separate adjustment to flotation costs, because again, you know, the premise or the underlying assumptions of those models is that there are no transaction costs in more of a theoretical world.
And but to the extent that the data does include historic returns, those returns, that historic data is reflected in the models.
Could I ask you to restate the question, please? I'm sorry, I'm not quite sure what the question is.
Sure. Could I have the judge's indulgence for just a minute?
Go ahead.
Okay, so a few minutes ago, we established that your analysis does incorporate certain historical return data, correct?
Yeah, and again, just as a point of clarification on a total market basis, not with regard to each individual company in the proxy groups.
Okay. And that historic data would reflect the costs that the publicly traded companies have incurred.
Of issuance costs?
Yes, to issue stock.
Well, there's an underlying presumption there that those companies had significant levels of stock issuance where they incurred transaction cost. You could make that assumption, I suppose, but I don't think we know that definitively. I think you almost have to look at each company on an individual basis to know when and where they've actually made equity issuances, because to the extent that they haven't, maybe they're self-sufficient in terms of the retention of earnings. So if they're retaining earnings at a sufficient level, there is no need to conduct an equity issuance. And for that reason, there would be no flotation or issuance cost. So I think it's kind of a broad generalization just to make that assumption.
Okay, thank you. But to the extent that they did issue or incur costs for issuing stock, it's reflected, correct?
I don't know that I'm in total agreement with that statement. I guess I would just respond that theoretically it's possible, but to my knowledge, there's no empirical evidence, or I'm not aware of any empirical evidence that specifically speaks to that particular point. Is it possible? I'll concede theoretically that it's possible.
Okay, thank you, Mr. Ray, and I have no more questions.
Thank you. Cross-examination from staff.
Thank you, Your Honor. Good morning, Mr. Ray. Kenneth Albert on behalf of staff.
Good morning.
If we could first, you mentioned today that you relied on that non-regulated proxy group to ensure a more robust analysis as part of determining the ROE. Is that correct?
Right, but again, I would also point out that we certainly didn't weight the non-regulated group as much as we did the utility proxy groups. The idea there is to present an analysis of what the competitive market result is. I think in OPC Witnesses, Garrett's direct testimony, he talks about regulation standing in the place of competition. So in other words, regulation is a substitute for competition. And those are the intents as per Hope and Bluefield. So I think just as another data point, to the extent that you're not overly relying upon that information, that does reflect the competitive market result, since again, regulation is in fact intended to stand in as a substitute for competition.
So for example, I think you list these companies in your non-regulated group in your exhibit VVR-9. And just so we have an example, something concrete, two of the companies are two beverage manufacturers, Pepsi and Coca-Cola. I'll refer to them as Pepsi and Coke. And those two companies aggressively compete in the beverage industry for customers. Is that correct?
I think that's a fair characterization, yes.
And I want to just briefly review with you some of the cost recovery mechanisms that Columbia has that would affect an analysis of the risks that Columbia faces. Now, I did send these documents to all parties at least a couple of times. Do you have those available to you?
I do. I did download those. So if you could just give me a minute or so as you have questions on them, I could certainly call those up.
That'd be great. And Your Honor, if you'd like me to pull them up, I could do that. But otherwise,
Yeah, that would be, if you could share them, that would be even better.
Thank you. Thank you, Your Honor. Okay, the first cost recovery mechanism I'd like to review with you is the STRIDE program. You're familiar with this. This is the cost tracker surcharge that Columbia uses to recover facility upgrade costs, which includes a replacement of aging or deteriorated facilities, correct?
Yes, that is correct.
Now, let me, excuse me, I want to pull up my first document here. Now, I'm looking for something on the screen. Okay, I'm a little,
There's a share button at the bottom. That should work.
I don't see that on my, okay, let me go back. Okay, I've opened, I see. I'm looking at the bottom, which is that screen? I don't see the share function on here. I've opened the document, which I know is the first step. And let me see, it's the stop video. I apologize. I wanted to, more options. I'm having trouble I don't see a share direction. It's going to even help me out on that. I've done this once before. Oh, I see. I'm sorry. That's upper left-hand corner. Apologies. I did not notice
That's
that. So I'm clicking share and try full screen. Oh, let's see. I apologize. I'm having a little trouble here. Let me go back.
It's not, I have the documents and I believe the witness does as well. So
Yeah, I apologize, Your Honor. I was trying to
That's
practice
okay.
this ahead of time, but
that's okay.
it's difficult to do that. All right, let me get out of this screen. Bear with me a second. Okay, so I'm going, apologies again. That's I was hoping to pull these up. The first document I have, which is labeled as number 2, it's the Columbia March 12th, 2021 Stride filing. And if you go to Schedule 3, Sheet 1, it shows under line 1, column 3, the 13, that line 1 is 13-month average plant. It shows in 2020, the investment total, that's column 3, is $4,726,206. Now,
Counsel, can you just give us a page number again? Make sure
yeah,
everybody's.
apologies. Yes, that's on Schedule 3, Sheet 1 of 1. And I'm on line 1, column 3.
Mr. Ray, are you there?
Yes, I see it. So the value that I see, just to repeat it, is roughly $4.7 million.
That's right.
Okay. Yes,
Thank
yes, I
you.
see it.
Okay, and now if you go in that same document to, no, excuse me, I'm pulling up a different document. So, Your Honor, that we would like to mark that filing, which is my KA2. I think we're up to Staff Exhibit 13, if I'm correct on that. So we'd like to mark that for identification as Staff Exhibit 13.
Okay. So marked.
Okay, now let me move now to what I have as my exhibit number 3. This is, it's a document from NiSource entitled Supplemental Slides 2Q 2021 Results.
I'm sorry, was that labeled properly? Because when I call up KA3, I'm seeing a tariff. But I do have the supplemental slides for NiSource in another spot, but it's not labeled KA3.
What is it labeled as?
It's not labeled.
Okay, sorry, but I may have sent you an earlier version, but yes, if we could go to that document, please.
Okay, so we're talking the NiSource supplemental earnings slide for Q2 21.
That's exactly right. Supplemental slides 2Q 2021, August, dated August 4th, 2021.
Okay, I do have that document here.
Thank you. Let me pull down, apologies, like I said, for not knowing how to share here. I'm on page, I'm not sure these things are labeled. Yeah, unfortunately,
There should be a label in the yellow section on the right side.
I'm sorry, thank you. Yes,
There's
it
a
is.
page number. Mhm.
I didn't see that. That's a page 11. I'm sorry, bottom right-hand corner. So in yellow, you'll see a white number 11. And just the point here is that this page indicates that the NiSource gas utilities in Maryland, Indiana, Kentucky, Ohio, and Virginia, that is, rely on a cost tracker akin to the STRIDE to recover the cost of facility upgrades, correct?
Yes, that is correct.
And if we can move up on this document to page 7, this indicates the bar graph there indicates that the NiSource utilities recover the majority of their capital expenditures via cost trackers that allow recovery of the CapEx costs within 18 months, correct?
If I could just have a second or so just to briefly review this particular slide, I'd appreciate that.
Sure, sir. Yeah, please let me know when you need more time to review a document. That's no problem.
Okay, so as I'm reading this, and this again looks at the forecast period from 2021 to 2024. Yes, it does in fact show that the gray sections of the bar is tracker recovery within a period of 0 to 18 months.
And
So-
again, I'm sorry, I didn't mean to interrupt.
No, that's okay. That's okay. No, I was just going to say that is obviously a significant portion as demonstrated graphically there on this particular slide.
And
Mr. Ray, can you please get closer to the unit or speak up again?
Okay.
And Mr. Ray, the text at the bottom of that page actually says that NiSource quotes anticipate greater than 75% of capital investments begin earning less than 18 months.
Yes, I do see that. And can you hear me okay?
That's much better. Thank you for leaning into the computer.
And Mr. Ray, in your exhibit VVR-4, you cite the upgrade cost recovery mechanisms used by the members of your proxy group, correct?
Let me just confirm that that is the right exhibit. Yes, exhibit VVR4 does present regulatory mechanisms for the proxy group companies.
And to more generalize it, many states are allowing utilities, because of the large amount and the regular frequency of these CapEx expenses, many states are allowing utilities to rely on cost trackers outside the context of a rate case, correct?
Yes, generally that is correct, yes.
Now, would you agree that that would reduce the risks that a utility faces, the whole concern being about regulatory lag and the need to file a rate case with all the delays and the costs, as we see in this proceeding, associated with that? Would you agree that the ability to rely on a cost tracker does reduce risks faced by a utility?
I think it depends on the individual tracker, that to the extent that you're reducing regulatory lag and getting quicker cost recovery, arguments could be made that that is perhaps at least theoretically risk reducing, but in many cases those trackers don't necessarily assure cost recovery. You're still going through the same types of prudency reviews that you would have to do for purposes of any other capital requirement that has to pass muster with the incumbent regulatory commission. But I think perhaps the more salient point is that even if you concede on a theoretical basis that some of these mechanisms have the effect of reducing risk, it's really academic, because at the end of the day, when you're determining the cost of equity, you're using market-based data of proxy group companies that already reflect all these mechanisms. As you just made the point, these mechanisms are ubiquitous. They're generally found throughout the industry, the gas industry, and maybe perhaps a lesser extent to the electric industry. And for that reason, the marketplace has already incorporated any such hypothetical effects of risk reduction into the stock prices. And therefore, to the extent that you've done a cost of equity analysis, you've essentially already incorporated those effects.
But you're aware of the fact that this commission and other state commissions, several state commissions have addressed that argument. And I appreciate it. You're looking at certain quantitative factors. Those commissions have looked at, I guess, the more global qualitative factors and repeatedly said that because of the fundamental difference between a utility and a company, a competitive industry, is by definition that a utility faces no competition and is the monopoly distribution company with respect to an essential good, that is natural gas, that the risk of the utility is significantly lower. Is that correct?
I totally disagree with that. And you see that in the comparative risk assessment that I conducted in my direct testimony. It's not just me saying this. It's the rating agencies saying this, whether it's Moody's, S&P, or Fitch. If you look at the comparative risk assessment that I conducted for purposes of my direct testimony, those three rating agencies are very clear that industry matters, but not to the extent that you're presenting. When a rating agency conducts a credit analysis, they incorporate differences in business practices and, across industries, and that the nuances of each industry. The product of what they're producing in their credit analysis and their ultimate credit rating looks beyond industry. And the whole idea of a credit rating agency rating, a long-term credit rating, is to provide a rating that could be consistently compared across industries. And so, yes, regulated utilities, obviously, they're so-called natural monopolies. They have a fixed service territory. That's true. They don't face competition necessarily in the traditional sense that a non-regulated company would, but they also have other risks that non-rate regulated companies don't have, like regulatory risk. They don't have the ability to expand into other service territories. They're locked into a particular service territory. The rating agencies take all of those considerations into their analyses, they factor them in, and they provide credit ratings that are comparable across industries. So if a rating agency is providing, say, an A or A- rating, in the case of Moody's, for a non-regulated company, and a particular regulated utility has the same credit rating, they are perceived as having equivalent risk levels from the perspective of the rating agencies. So I don't agree with the premise, because it is true that the utility industry has different risk factors than non-rate regulated companies, but those different risk factors are certainly taken into consideration by the rating agencies when they come up with their credit ratings that they publish.
Now, you say utility is locked into its service territory. You do understand, you do recognize that, in fact, it's happened in Maryland on a regular basis. Utilities have expanded their service areas, acquired franchises in nearby towns because of the high demand for natural gas. So you agree that, well, yes, so I appreciate the fact you can't be invading another utility's service territory. Certainly, utilities regularly push to expand into adjacent areas that don't currently have gas service, correct?
Oh, I would totally agree with that comment.
Now, let me get back to the upgrade cost track or stride. I want to complete the circle on this one. Again, use our example of Coke and Pepsi. If Pepsi upgrades its manufacturing plant and they increase the price of their beverages to cover the cost of that upgrade, Pepsi would face the risk of losing customers and market shares to its competitors, such as Coca-Cola, correct?
I guess I would agree with that.
And a utility, in fact, can flow through upgrade costs through a tracker, even if there have been offsetting reductions in the utility's operating costs in a period after the utility's rate case, the prior rate case that established its current rates, correct?
Generally, I agree with that, yes.
And in fact, an example would be that's often cited is Stride is replacement of gas pipe, and often the reason for that is this pipe is leaking gas. That is, gas is escaping from the pipe. So when that replacement is done, gas loss, which is an operational expense, is invariably will go down, will decrease as compared to the level of gas loss that was reflected in the utilities rates, correct?
Generally, I would agree with that comment.
Okay, let me move on to another mechanism. I think I'm just covering 3 of them here. The revenue normalization adjustment. Now, I'll refer to your direct testimony on page 42. Line 13. Excuse me, line 13.
And counsel, are we in the direct testimony?
Yes, I'm sorry, sir. Carville, that's the direct testimony. Page 42, line 13.
Thank you.
Now, here you say that, and I'm quoting, more specifically, and as reflected in exhibit VVR-4, my evaluation determined that all 7 of the companies comprising the gas LDC group and that 8 of the 9 companies comprising the combination utility group employ forms of revenue stabilization mechanisms. And then I'll refer you now to my exhibit 4, which is the Columbia tariff, and specifically second revised sheet 56. And this describes how Columbia, this authorizes Columbia to adjust its rates on a monthly basis to ensure that Columbia recovers the per customer base distribution revenue that underlies Columbia's current rates as established in its most recent rate case, correct?
Right, and one point that I would make, though, and I do recall this from the work that we did in terms of exhibit VVR-4, is that Columbia, Maryland's RNA program, although obviously it's constructive for the company, it's not as robust as what we see with regard to the proxy group companies, because in the case of Columbia of Maryland, the RNA only applies to the residential customer class. We do see in exhibit VVR-4 that a lot of the mechanisms also go beyond the residential class. So I would have to argue that although this is a constructive mechanism, it's probably not as robust as what we've seen in other utility companies nationwide.
Your Honor, just to clarify, I will be discussing 2 or 3 portions of Columbia's tariff. I just want to clarify that the tariff will be considered as part of the record. In other words, I don't have to introduce into the record each specific provision I'm referring to, the whole tariff. And again, the logic would be there. The tariff is, of course, a document that's been approved by the commission. So we would ask that, just for clarification, that we can cite in our briefs the entire Columbia tariff.
Yes, I'll take notice of the tariff.
Thank you, Your Honor. Now, to add a little, these mechanisms are kind of theoretical, so I thought it would be helpful to put in the record what I have labeled as KA5, a recent RNA filing. Again, the purpose here is to give a full flavor of exactly what the RNA mechanism actually does. This is the surcharge for the billing month of April 2021 based on February 2021 revenue filed in mail log 234118.
And counsel, is this the filing dated March 11th, 2021?
That's correct, Carville. Yes, this is that filing which I circulated as KA5.
Thank you.
And let me go to I'm on page, excuse me a sec here. Schedule 1, page 2 of 2.
Okay, I'm there. I'm seeing a title of Calculation of the Monthly Residential Revenue Normalization Adjustment.
Yes, exactly. Thank you, Mr. Ray. And now direct you to line 14, where it shows that the total customer growth adjustment, line 7 plus line 13, is $47,594.
I see that line.
So that essentially shows the adjustment. The RNA mechanism takes that total number of customers, the current number of customers, and multiplies by the per customer base revenue approved in the most recent rate case, correct?
Was that a question for me?
Yeah, I just want to understand that that's your understanding of how the RNA mechanism works.
Generally, yes. I'm not directly involved in these particular filings, but subject to check, I would agree with that. But again, I'm not directly involved in these filings.
Sure, and I appreciate that. Though again, my point, since we all, it's clear that the ROE must be, use the court's words, commensurate with risk. Risk is a key feature in determining where the ROE, is established. The point here is not to, I appreciate you not involved in the RNA adjustment, just to make clear that this is relevant to the issue of the risks faced by the utility. But I'll move on.
Well, if I could just clarify a point. So
please.
I would concede that at least from a hypothetical standpoint, it impacts risk in isolation for Columbia of Maryland. So in other words, if you're analyzing Columbia of Maryland in a vacuum or in isolation, you could argue hypothetically, yes, it's risk reducing. But again, the salient point for purposes of this proceeding, in my view, is how you go about calculating or estimating the cost of equity. And so if you're looking at this in isolation, there may be at least some hypothetical basis for that, but that's not how the cost of equity is being estimated. It's being estimated on the basis of market data of proxy group companies that already incorporate the same type of mechanisms into their earnings, into their stock prices, so on and so forth. So I think the key distinction is what viewpoint are you taking? Are you looking at this in isolation? Are you looking at it in the context of all other gas utilities in the country, for the most part, using these same mechanisms and therefore having these alleged risk reducing effects already baked into their market data that's used to determine or estimate the cost of equity?
So thank you for that, because again, essentially you're saying in determining what companies you compare the utility to during a utility rate case, you're looking at these these rate provisions that bear on the risk that the utility bears, and you make the point that your gas utility proxy group is appropriate for the very reason that they share, as a general matter, they share this the decoupling, as it's put, with this RNA mechanism that Columbia has. Do I have that correct?
You do, and I would actually expand that to also include the combination gas and electric utility proxy group that I referenced. And that's why we spend a lot of time in developing direct testimony to ensure that we go through the 10K filings. We also go through the 10Qs, we go through investor presentations. We want to be absolutely sure that we're understanding the types of mechanisms that those companies are using as it relates to revenue decoupling and also infrastructure cost recovery mechanisms.
And to close the loop on this issue of the common nature of these RNA mechanisms, my exhibit 6 is just the the NiSource SEC 410K. I asked people to go to page 8 on that one.
Okay, and just a point of clarification, when I call that up, I don't see a NiSource 10K. I see Columbia Gas of Maryland rates, rules, and regulation for furnishing gas service.
Okay, I apologize. Can you take a look at the list of docs? There should be a 10K. I just have one sentence to read, but I did intend to.
Yes, if you could please read that to me, it might be the
Sure.
most expeditious way.
I'm sorry, I didn't mean to interrupt. On page 8, there's a heading at the top of the page, competition and changes in the regulatory environment. and go to the third paragraph, the sentence that begins at the end of the third line of that third paragraph, and I'll quote it. Columbia Gas of Ohio has adopted a decoupled rate design that closely links the recovery of fixed costs with fixed charges. Columbia of Maryland and Columbia of Virginia have regulatory approval for weather and revenue normalization adjustments for certain customer classes, which adjust monthly revenues that exceed or fall short of approved levels. And again, in this statement, just the simple point that NiSource acknowledges that its affiliates in some of the other states also have a revenue normalization adjustment. And you do in your VVR-4 point to the members of the proxy group that have these RNA mechanisms.
Yes, that's correct.
And again, to go back to our straw man here of Pepsi and Coke, if customers reduce their consumption of Pepsi's beverages, and Pepsi utilizes a mechanism similar to Columbia's RNA to increase the price that Pepsi charges for its beverages to make up for the revenue that's lost due to the drop in demand for Pepsi's products, Pepsi is going to run the risk of losing customers and market share to Pepsi's competitors. I'm sorry. Let me repeat the last part of that. Pepsi runs the risk of losing customers and market share to Pepsi's competitors. Is that correct?
That's correct. But again, I would emphasize that each utility has a different set of risk. And I would just go back to my earlier point about what matters is looking at the totality of those risks. And that's the exercise that the credit rating agencies go through. I'm not disputing the observations that you're making. I'm just saying that when you're looking at risk on an overall basis, you have to look at the totality of the risk. That's what the rating agencies do. And if you were to refer to table VVR-4 of my direct testimony, you'll see that if you look at it objectively and on a verifiable basis, the rating agencies have concluded that the non-regulated group that we use, and we specifically choose non-regulated companies that have very low risk profiles, just to provide some idea of what the competitive result would be as per Hope and Bluefield. Again, I'm not disagreeing with your comments. I'm just saying that you have to evaluate the totality of the risk across industries before you could come up with a comprehensive risk analysis. And that is reflected in table VVR-4 in my direct testimony.
Though again, this commission and other commissions have considered that argument. They've looked at those. I certainly agree with you that you could find these quantitative financial factors, but this commission and other commissions have said, essentially, you can't just look at these quantitative financial factors that these investment rating companies look at. You have to look at the big picture as well, which is you're dealing with a company that has a captive customer for an essential good versus a company that's involved in a competitive market where it can lose market share, it could lose its entire business. That's a risk that it faces on an ongoing basis, correct?
I agree, but again, the rating agencies value line as well, which is part of my comparative risk assessment. They've already taken all those considerations into effect. They're looking at the totality of risk. You can argue that utilities have a whole different set of risks that non-regulated companies don't have. And for that reason, I'm not disputing your comments. I'm not disputing your observations. I'm just saying, again, what matters is the totality of the risk. So it's not just me saying it, it's the rating agencies. And the rating agencies, again, they prepare credit ratings that are comparable across industries. And again, if you refer to table VVR-4, you'll see that the non-regulated group, that the companies we chose, we can argue monolithically, on a monolithic basis, that non-regulated entities are riskier. That's not the purpose of my analysis. My analysis doesn't look monolithically at all non-regulated companies. It specifically picked non-rate regulated companies that have risk profiles that meet the corresponding risk standards as per Hope and Bluefield, and that is used as the basis for understanding what the competitive market result is. So again, I'm not disputing your comments or your observations. But I just want to be clear that we can't view non-regulated companies in a monolithic sense, when in fact there are plenty of non-regulated companies that actually do have risk profiles that are comparable to regulated utilities.
And would those companies include Columbia?
I'm sorry, can you clarify that? I'm not quite sure the context of that.
I'm sorry, you said specifically that some utilities have a risk profile similar to that of a company, a competitive company. And my question was, is Columbia one of those companies that you would say has a similar risk profile to a competitive company?
Just as a point of clarification, what I said was that we can't view all non-regulated entities monolithically. They all have different risk profiles, different industries, different capital structures, different financial risk profiles. There is a subset of non-rate regulated entities that have risk profiles that are comparable to regulated utilities when you look at the totality of risk as independently, verifiably proven by the rating agency reports. Those companies provide a reasonable basis for the corresponding risk comparison as dictated by Hope and Bluefield. And what I would argue is, yes, a lot of those non-rate regulated companies do have risk profiles on an overall basis, again, based on the totality of risk. I just want to repeat that point, that are comparable to regulated utilities, or perhaps could even have a lower overall risk profile. You can't treat the entire non-regulated group of companies as being monolithic, though, and that's why we're very careful. We go through a process, we're very circumspect in ensuring that we're only looking at non-rate regulated companies that fit the corresponding risk standard. Is that responsive to your question?
Yeah, thank you for that. Let me go, this is the third and I promise the last rate mechanism we're going to be covering here. This is the purchase gas adjustment clause. You're aware that Columbia relies on a cost tracker called the Purchase Gas Adjustment Clause, or PGA, to recover Columbia's purchase gas costs, along with the cost of third-party pipeline capacity that Columbia relies on to deliver gas from upstream supply sources into the Columbia gas distribution system, correct?
But I would also point out that I believe that most regulated utilities, most if not all regulated utilities in Maryland have the same mechanisms as do most gas regulated utilities across the United States.
Okay, and thank you for that. And that is the PGA is in sheet 125, or 8th revised sheet number 125 of the tariff. I wanted to bring up an actual PGA. Again, I think it's important to cite these mechanisms, but I think to give a full flavor for the record of how these mechanisms operate, I wanted to introduce into the record a recent PGA filing by Columbia. And this is a June 25th, 2021 filing by Columbia to revise its PGA surcharge. This is an ML mail log 235879.
Is this one of the attachments that or exhibits that you provided for this hearing?
Yes, it is, sir.
I'm sorry, which number is it?
This is number, bear with me a second. This is the filing is number 9.
Okay, I do have that. Let me just make sure it's consistent with the order.
And counsel, is this a filing dated June 24th, 2021?
Yes, that's correct.
Filed by Ms. Danhires, June 24th, 2021, Mr. Ray.
Okay, I do have it.
Okay, and we'd like to mark that filing as staff exhibit 17.
Mark.
So I have in my list, just to make sure I'm correct here, I've got the KA2 is exhibit 13, KA3, exhibit 14, KA5 is exhibit 15, KA6 is exhibit 16, and KA8 is exhibit 17. Again, the only reason here, sir, is to just give a little flavor to how exactly this mechanism works. I would refer you in this document to, let's see, it's statement number 408, Schedule 1, page 3.
Is it sheet 3 or page 3?
Let me see there. It's labeled, I'm sorry, you're right. It's labeled sheet 3 of 7.
I've got it.
Schedule
Yes.
1, sheet 3 of 7, and it says statement 408.
Yes, I do have that.
Thank you. And if you look at line 9, that's the total commodity cost of gas. Sheet 4, line 7, that's $10,007,865. And then if you go down to line 14, $9,700,718. You're comparing to our Pepsi and Coke example. If in a competitive industry, a company wants to flow through a cost akin to the PGA, and this will increase the price of the company's products, that puts the company at risk of losing customers, revenue, and market share, correct?
Yes, that's correct.
Okay, I want to talk a bit about the dividend, and here I want to introduce what I labeled as KA10. This is it's a NiSource document, 2020 Integrated Annual Report. Let me pull this up. And I would refer you to page, let's see if these are labeled here. Okay, these are not labeled. I think it's the third sheet. When you pull up that document, on my screen with this document, it gives pages 3 of 30. There are no page numbers on it. You able to locate that?
Does it show serving nearly 4 million?
It starts, let's see. Yes, thank you. That's the caption at the top, serving nearly 4 million.
Okay, I've got it.
I wanted to direct your attention to the, let's see, the paragraph in the middle of the right-hand side of the page, beginning with, we expect to grow our non-GAAP net. And if you go down in that paragraph, I'm focusing specifically on the sentence that goes, let's see, it's 6 lines down, begins at the beginning of the line. We plan to grow our dividend to maintain our targeted 60 to 70% payout ratio, and we plan to finance our growth in a balanced way that's focused on maintaining our current investment grade credit ratings. So they're paying out, NiSource is paying out 60 to 70%. Is your understanding that that is a higher level of payout, dividend payout than competitive companies?
Generally speaking, the answer to that is yes. I think utilities are well known for paying a higher percentage of their earnings, retained earnings, in the form of dividend payments. That is correct. And
then that large and stable revenue that NiSource investors get through the dividend, that would be considered that would significantly reduce the risk of holding a utility stock, correct?
Generally speaking, yes. But again, I would argue that it would depend on the individual company. Again, I'm hesitant to treat an entire industry in a monolithic way. It depends on the individual utility.
But all things being equal, and I'm an investor, I have 2 companies, equal risk, everything's comparable. One gives me a steady dividend, one doesn't. Would you agree that the steady dividend would be an important factor for that investor?
Yeah, I agree that utility companies, again, are known to pay predictable, stable dividend payments. And that is kind of the so-called quid pro quo for lower levels of returns, actually, that utilities are granted, relative to dividend payments versus growth. Yes.
And you cite the issues come up in connection with beta about the heightened volatility in stock prices once COVID emerged in early 2020. And you'd agree that a steady dividend has become especially valuable to investors during periods of heightened volatility in stock prices, correct?
Right, and just, one footnote, though, I think, over the past year or so, we've also seen the impact of trends towards decarbonization. And I think we saw in the latter half of 2020, the gas utility sector underperformed because concerns about trends towards decarbonization. So I wouldn't say that it's just all COVID. I would say there was a pretty large effect relative to that factor as well.
Well, that's perfect. Yeah, thank you. That's a beautiful segue to where I'm going next on this same document, the integrated annual report. Let's see, I've got it as I think it's the second sheet labeled just on that point. Yes, and you do make that point, Mr. Ray, about concerns about decarbonization. So I wanted to see what point you to, let's see, is this the second or third sheet on that 2020 integrated report? The second sheet, labeled top left of my screen, is 2/2 of 30. Do you have that?
I just want to clarify, which document are you looking at now?
I'm sorry, sir. Sorry for not clarifying that. It's the 2020 integrated annual report, the document we were just referring to.
The previous, the one, I'm on the first page of that document. That's the NiSource document that opens with deepening our commitments, the 2020 integrated report.
That's correct.
Okay, I've got too many documents up here on my screen. Okay, so I'm sorry, which page or sheet did you want to go to?
Bear with me 1 second. I'm pulling it up myself here. I'm on, let's see, I'm on the second sheet, since we don't have page numbers on this one.
And does that appear with the year 2020 at the top in light blue color?
Yes, thank you for that. Yes, I'm sorry. I should have said that to make it a little bit easier. Yes, it does. And again, as you note in your testimony, you point about concerns about decarbonization. I want to direct your attention to the statement, bottom right-hand side, and I'll read it. The foundation for our future is strong. NiSource is a 100% regulated gas and electric utility with significant scale across 6 states. Our footprint is located close to abundant, low-cost gas resources, and our investments and cost recovery programs are supported by favorable energy policies and constructive, bear with me a second, constructive environments. And on that, let me just note another statement in that same document on the next page. If you go to that next page, and let me, using your example, tell you what's at the top of that page to make it a little bit easier. The next page, serving nearly 4M natural gas and electric customers. NiSource says, the bottom right-hand side, under the heading Future of Natural Gas, we and other natural gas utilities have faced questions about the sustainability of natural gas in a decarbonizing economy. At NiSource, we are bullish on natural gas and believe that natural gas will continue to play a critical role in the clean energy transition. Now, in view of those two statements, clearly suggest that NiSource is aware of this, that some people are advocating decarbonization, but NiSource does not think they're at risk because of that. Is that correct?
I'm not sure I would characterize it that way. I think they're cautiously optimistic, but I think that maybe what's more germane to the analysis is looking at what the equity analysts and rating agencies are saying about it. And there are some concerns. It's not necessarily something that's a dire issue, but it is something that's out there. It is a risk factor that's out there that increases risk for all regulated gas utilities.
Now, let me switch topics here. the concept of, what is your understanding of from an investor's perspective, what the concept of opportunity cost means?
I think the perfect example of opportunity cost would be the question that Mr. Carville asked me relative to rejoinder testimony relative to the recent outcomes in Maryland for other gas utilities such as WGL and Baltimore Gas and Electric, BG&E. Those are outcomes, again, as I pointed out earlier, that are based upon fully litigated proceedings that represent a balancing of interest between the company's customers and the company's shareholders. That, to me, those two outcomes in particular are probably the best example of the opportunity cost of capital, what I consider to be the minimum required return for a utility like Columbia of Maryland, because it's consistent with the comparable earnings standard as per Hope and Bluefield. So in other words, we've got two other utilities in the same state that have recently been authorized ROEs in the range of 970, or in the case of BG&E, 965. Again, that represents the balancing of interest from fully litigated proceedings. So that, to me, is kind of a classic definition in the current environment of what the minimum required opportunity cost of capital is.
Would you, though the opportunity cost of an investment, would it also refer to the fact that, the simple fact, if I'm choosing one, I'm balancing, let's say, between stocks and bonds or stocks of different companies. By choosing one, I'm essentially passing up the other. So I'm doing a comparative analysis of the return, whether they be comparable stock versus stock or stock versus bond. There's a weighing of the two. Is that correct?
Right. I agree with that comment. I think that in order to determine the opportunity cost of capital, the first question you have to answer is whether or not you're talking about comparable risk, or if you want to, kind of refer back to judicial precedent, it would be corresponding risk for the Hope and Bluefield cases. But yeah, that you need to have that right out of the gates. It has to be comparable risk to identify what the opportunity cost of capital is.
Right. And with the opportunity cost, again, all things being equal, you have two companies very comparable from an investor's perspective. If the return on one of those investments drops, presumably the investor would require a corresponding lower return on that other investment. They're comparable. They're being compared, as that's the opportunity cost concept, that the investor is constantly comparing the returns on comparable investments, as you say. So therefore, a downward return on one investment would be a factor, not perhaps the only factor, but would certainly have a downward impact on the return that that investor requires from the other investment opportunities, correct?
Well, I think it's important. It's really a matter of whether or not you're looking at one particular company in isolation, or if you're looking at outcomes across the board. For purposes of the instant proceeding, we obviously look at recent outcomes in Maryland, but we even look beyond that, recent outcomes across the United States, which is obviously information that's published by RRA SNL. So generally speaking, I guess to be responsive to your question, I think it would depend upon the population of companies that you're actually looking at in terms of who you're comparing to. So generally speaking, to the extent on more of a aggregated basis, whether you're looking at outcomes in Maryland, or aggregated basis, whether you're looking at outcomes across the United States, yes, I mean, it's a matter of what the authorized returns are, what the company is actually earning, because obviously utilities don't always earn their authorized ROE. Sometimes they over-earn their authorized ROE. I think you can't look at one other entity. You basically have to treat these matters in the aggregate.
Okay. Let's go to the last topic here, the size adjustment. Now, you repeatedly here offered me wonderful introductions to the next topic. You and I are definitely in sync on this, and I appreciate that. You did mention Pepco and BGE, and you did say, hey, those guys are a lot bigger, clearly much bigger companies than Columbia. So your view that 9.65 BGE, that 9.7 Washington Gas Light is not comparable to what a Columbia would demand. Now, let me just touch on your testimony, page 72 of your direct. And line 10, the sentence in the middle of that line, you refer to, well, let me start line 9 to get complete thought. Multiple academic studies have advocated the use of a size premium adjustment to the traditional CAPM. These studies have revealed that small capitalization stocks have historically earned returns that are materially higher than the returns predicted by the CAPM. Now, did any of those studies that you cite specifically address whether these higher returns for a small capitalization stock apply to a regulated utility?
Yes. So I'm trying to recall, I think it was probably addressed in my rebuttal testimony, and I could cite the page in just a second here, but there's 2 studies, actually there's 3 studies, and then there's recent outcomes of FERC regulatory proceedings as well. So the 2 perhaps older studies, and when I say older, I mean within the past couple of decades, would be a study by Annan, another one by Zepp. I think it's Thomas Zepp. And I cite those in my rebuttal testimony. And then more recently, we've seen that Roger Grabowski from Duff and Phelps has also talked about the fact that the size premium is alive and well. So, and I could cite you to those sections of my rebuttal testimony in just a section. I think it's also important. It's also important to note that in recent years, particularly in FERC opinion 569, 569A, and 569B, the FERC has been very clear that they have not been persuaded by arguments that the size premium does not apply to the utility industry. FERC has been very outspoken on this point in those particular orders that I just cited, again, 569, 569A, and 569B, that the record evidence in those particular cases presented by intervening parties did not establish a strong enough basis to say or determine that the size premium does not apply to the utility industry in general.
But you're aware, and staff does cite studies that specific. I mean, I appreciate you've cited studies, but staff does cite studies as well that go the other way, that specifically say there's a size adjustment, but it does not apply to a regulated utility, correct?
I think that's always going to be the nature of the beast, that you're going to see, arguments, from opposing sides. Let me find the section here in my rebuttal testimony. Generally, it's in the area of like page 37 to maybe 42 or so in rebuttal testimony. And if you would like to have additional citations to that, I can certainly provide it. But I'm sorry, what was your follow-up question?
No, just to clarify again that this is somewhat of a disputed issue. Certainly there are studies, and I appreciate you've cited some, but staff does cite studies going the other way as well. Now, let me ask you that what factors, given a utility's monopoly status, what factors would explain a higher, if it's a smaller utility, you agree with me that that smaller utility, like Columbia, still has a monopoly in its service area. It still has the same cost recovery protections. We've talked about the RNA. We've talked about the Stride upgrade tracker. We've talked about the purchase gas tracker. I mean, those features that are key to the evaluating the risk for an investor don't change simply because Columbia is admittedly a smaller company.
Well, I'm sorry, if you look at the composition of gas throughput for Columbia, I think the gas throughput to residential customers is somewhere in the range of maybe 25 to 30% of the total throughput. So that leaves, on balance, maybe 65 to 70% of the gas throughput that serves commercial, industrial, and transportation customers. Those customers are more susceptible to the ebbs and flows of the business cycle. So Columbia, when you look at Columbia on a standalone basis, which is required as per judicial precedent, to have an economic situation, a market disruption like we saw in 2008, 2009 during the financial crisis and the Great Recession, or certainly what we've seen with COVID, a smaller company, which needs to be treated on a standalone basis, would in fact be more susceptible to those market disruptions. It's been demonstrated in finance literature that smaller companies face higher levels of both business risk and financial risks relative to larger capitalization companies. And I just provided an example of that, how it relates to severe market disruptions like we saw in 2008 and 2009, and certainly during the early stages of the COVID crisis as well.
Well, thank you, Mr. Ray. I think that's all I have. And Your Honor, can I now move into the record? I have as my list KA2, which would be Staff Exhibit 13, KA3, which would be Staff Exhibit 14, KA5, which would be Staff Exhibit 15, KA6, Staff Exhibit 16, KA8, Staff Exhibit 17, KA9, Staff Exhibit 18, and KA10, Staff Exhibit 19. We would ask that those be moved into the record.
No objection.
No objection for OPC.
Your Honor, you may be muted.
I am.
Uh,
Thank you.
Well, let me close. Mr. Ray, thank you. I appreciated chatting with you. We've done this before, and I always learn more than a few things talking to you. So do appreciate it. Thank you.
Thank you.
Thank you. So the records here, exhibits 13 through 19 were admitted without objection. I did have one question for Mr. Ray. Page 18 of your rebuttal, rebuttal testimony. I'm sorry, it's page 18 of staff's rebuttal testimony. Ms. Kuykendall did a recalculation of the flotation cost. And in her testimony on page 18.
I'm sorry, Your Honor, we're in rebuttal testimony here then?
Yes, that would be staff's rebuttal on page 18.
Okay.
Ms. Kuykendall?
Yeah, that's Staff Olivia Kuykendall.
Yes.
Your Honor, I'm sorry, where are we on that page, on that document?
Page 18, it begins actually on page 17. I apologize, line 13. Mr. Ray, I think there was an additional exhibit VVR1R that was provided to her to recalculate the recovery of flotation costs, which she did following on page 18 and provided a table 2S. I would just, my question to Mr. Ray is, are you in agreement or disagreement with her recalculation? And if you could explain why, your reasons, either way.
Okay, well, first I would point out that just more generally speaking, the commission's methodology for calculating flotation cost, I've been involved with Columbia, Maryland cases for probably the past 8 or 9 years now. And that calculation methodology is clearly different than the calculation methodology that I employ. Again, it's not whether who's right and who's wrong necessarily in this particular case, but I just want to establish for the record evidence that it's a different calculation methodology. My methodology, I obviously support. I wouldn't provide it in direct testimony and speak to it in rebuttal if I didn't support it. That being said, I think what Ms. Kuykendall did in this analysis was basically pick up additional flotation costs that were maybe unclear based upon direct testimony, and that she did incorporate additional transactions. And there's been a recent transaction where NiSource issued equity units in April of 2021, which is a fairly complicated or convoluted transaction because it involves forward agreements and mandatorily preferred, and so it's fairly complex. But long story short, to be responsive to your question, I do think that this is an improvement from where we were in earlier stages of the proceeding. I think essentially what she's proposing here is a little over 2 basis points. I've recommended anywhere between 5 and I think 6 basis points. So I would recognize that she has in this particular table here, table 2S, recognize the additional equity flotation costs that were not previously recognized. And I would just say that the outcome here is consistent with what I've seen for purposes of past precedent, but it's not necessarily the calculation methodology that I would use. Is that responsive to your question?
Yes, thank you. And I apologize, Mr. Collins, was there any redirect of your witness?
Yes, Your Honor, but very brief. Thank you. Mr. Ray, you had a very interesting conversation with staff counsel, and my follow-up questions are just in the nature of summarizing and trying to get to the bottom line of this very important discussion that the two of you had. I think I understood you to say that other Maryland gas companies like BGE and WGL have some of these same mechanisms that you've discussed, such as STRIDE, RNA, PGA, tariffs, and the like, correct?
Yes, that is correct.
And I think you've also said in your discussion that other Maryland Public Service companies also have these same mechanisms beyond just gas companies, correct?
Yes, that is correct.
So to the bottom line here, do these mechanisms have the ability to make any sort of material impact on the cost of equity?
I'm just going to mute. I'm going to mute for just a second. We have a fire engine going by right. There we go. Much better. So I'm sorry, Mr. Collins, can you repeat the question?
Yes. Based on the first two questions that I've asked you about the other utilities in Maryland, to try to get to the bottom line here, do these various mechanisms, STRIDE, RNA, PGA, and tariff provisions that you've discussed with Mr. Albert this morning, do these sorts of mechanisms have the ability to make any sort of material impact on the cost of equity?
Not in the context of determining the cost of equity for rate proceedings, because as I pointed out, the market-based data that we analyze represents other gas and perhaps electric utility companies that have many of the same mechanisms, and therefore can be the investment community, the capital markets have already incorporated those effects to the extent that they're present within the stock prices of those particular companies. So they're already reflected in the cost of equity of the market-based data that we use.
Thank you. No further questions, Your Honor.
Thank you. Thank you, Mr. Ray.
All right, thank you.
Is the company ready to call their next witness?
Yes, we are, Your Honor. And I think it will be Mr. Spanos next, and I'm going to let Ms. Moore turn it over to Ms. Moore for Mr. Spanos.
Thank you, Mr. Collins. And good morning for a few more minutes, Mr. Spanos. There you are.
Yep, sorry, camera wasn't working there.
That's
Thank
okay.
you. Good morning.
Morning, Mr. Spanos. Could you please raise your right hand? Do you swear or affirm under the penalties of perjury that the testimony you're about to give is the truth?
Yes, I do.
Thank you.
Mr. Spanos, for the record, can you please state your employer and your title?
Yes, my employer is Gannett Fleming Valuation and Rate Consultants, LLC, and I am the president.
Thank you. Mr. Spanos, do you have before you your direct testimony as well as attachments JJS 1 through JJS 4? and also your rebuttal testimony and attachment JJS 1R.
Yes, I do.
Was this testimony prepared by you or under your direct supervision?
Yes, it was.
Do you have any changes, corrections, or updates to the testimony?
No, I do not.
Is your testimony true and accurate to the best of your information, knowledge, and belief?
Yes, it is.
If you were giving the same testimony today, would your testimony be the same as when it was originally filed?
Yes, it would.
Your Honor, I would ask that the testimony and attachments of Mr. Spanos that I just listed be marked as Columbia Hearing Exhibit 13.
Mark?
And Your Honor, if there are no objections, I would ask that Columbia Hearing Exhibit 13 be admitted into the record.
Any objection from OPC?
No objection.
Any objection from staff?
No objections, Your Honor.
Thank you. The testimony and attachments, including the rebuttal testimony and attachments of witness Spanos, will be entered into the record as Columbia Exhibit 13.
Thank you, Your Honor. And we also have a bit of brief live rejoinder at this time.
Go ahead.
Thank you. Mr. Spanos, do you have before you OPC witness Guerin's surrebuttal testimony filed in this proceeding?
Yes, I do.
And have you reviewed the surrebuttal testimony, specifically page 2 concerning net salvage and loans?
Yes, it moves on to page 3 as well.
Yes, thank you. How do you further respond to Mr. Guerin's opinion that net salvage is comparable to a loan?
Well, I disagree with that. The Uniform System of Accounts, which is the main governing way of handling depreciation and the concept of depreciation, defines depreciation as the recovery of the full service value of the asset. And the full service value includes not only the plant investment, but also the net salvage component, which incorporates cost of removal and gross salvage. So under that recovery over the straight line method, it is not consistent with what would be defined as a loan, and the net salvage component should not be any different than that loan, or different than the plant recovery, and thus not a loan concept.
Thank you. Now, can you turn to page 4 of Mr. Guerin's surrebuttal? On page 4, Mr. Guerin states disagreement with his colleague, Mr. Majoros, related to the appropriate discount rate if using the present value method. Does his explanation support his position when the history of the present value method does his explanation support his position in light of the history of the present value method?
No, it doesn't. And I think I need to kind of tie the two components together. And first, understanding that depreciation is a cost allocation method and not a valuation method. And thus, FAS 143, which is the basis of the present value method, is a valuation process. So when you take that concept into play and then look at how Mr. Guerin has expressed his position from his colleague related to the discussion on page 4 of his surrebuttal, it's important to understand the chronological order of what has happened. And the first thing that we need to understand is the first time the present value method, or FAS 143, was even brought up in Maryland was about 13 or 14 years ago. So his discussion as to why I bring up a 12-year-old discussion from his colleague is very important to understand that about 14 years ago, the topic of the present value was first brought up in Maryland. And in that proceeding, they did not discuss discount rates. It was development of the straight line method versus compound interest and the rate of return component. So the first time, and the commission's position in that proceeding was they wanted to exclude inflation as a component of making sure that all customers paid their fair share. So when you take that concept into understanding the first time the discount rate was even discussed, because it's not discussed in any other jurisdiction other than Maryland and District of Columbia. In the District of Columbia, when the discount rates were actually discussed for the first time, it was agreed upon or approved in that case and discussed by Mr. Garen's colleague, Mr. Majoros, that the most appropriate reflection of the discount rate is inflation. And thus, in that particular area, his firm agreed that inflation was the most appropriate discount rate when looking at a present value methodology. We take that one step further. So now we've gone into other cases in Maryland when it's discussed, and even staff witnesses have agreed that the most representative portion, if you're going to be consistent with real dollar recovery, is the inflation rate. So the point that I think that is clear here is, as Mr. Garen tries to discuss in his rebuttal as to why these discussions were brought up, it's because of the fact when we really look at the situation that we have in hand here today, it is the position that the present value approach and the proper recovery so that all customers pay their fair share would be to remove inflation component into from the present value, and that's the appropriate discount rate for this particular proceeding, and that's why it's important to note that. And the only positions that OPC or staff have come up with since this time has always been, well, that was what was decided in the first case. Well, the first case, we didn't have the discussion on discount rates. So when they were discussed, inflation was the component, which is the 2.5%, which is the most representative. So that's the overall review of why this is brought up and why I thought it's very important to discuss the rebuttal of Mr. Garen and why a 12-year-old case is important, because it's actually more recent than the ruling in Maryland as to using rate of return.
Thank you, Mr. Spanos. Your Honor, that's the end of the rejoinder. Thank you.
Office of People's Counsel, cross-examination.
Yes, Your Honor, thank you. Just a few questions. Good. Looks like it's still morning by a couple minutes. Good morning, Mr. Spanos. How are you?
Good morning. I'm fine. Thank you.
Hi, I'm Joe Cleaver from the Office of People's Counsel. Just wanted to ask you a few things following up on your conversation you just had with your attorney. The first concerns your discussion of Mr. Garen's discussion of loans in the context of the net salvage discussion. In his rebuttal testimony, Mr. Garen doesn't make the claim that the net salvage concept is identical to a loan, does he?
He makes the statement in his initial testimony that it's the net salvage component is a loan, and then corrects it and stating that it was a misstatement. So he's not stating that it's a loan, but I think that the important concept is understanding that the net salvage component is a part of the full service value of the asset, should not be treated differently, because clearly Uniform System of Accounts describes it as being a similar concept to the recovery of plant and service, and is a reduction of rate base when applied to depreciation expense. So that's the concept that that I was talking about in my rejoinder related to his discussion of net salvage and loans.
Yeah, he doesn't say anywhere that he made a misstatement in his direct, does he?
That's in discovery that was where he stated that concept.
He he says right here that he stands by the statement in his direct testimony. I'm looking at page 2, line 15 of his surrebuttal testimony. Do you see that? Excuse me, page 3, line 15.
I see that he's saying that, however, in my opinion, the statement from direct testimony stands as readily understandable as an analogy to the most common context. So I see that there, again, based on his discussion and what he has written in prior cases, those are where he discusses the misstatement.
I'm sorry, I'm trying to understand what you're saying. Are you saying that in testimony in this case, Mr. Guerin claims that he made a misstatement? Because that's what I thought I heard you say, and I want to clear that up.
My reference is based on a discovery response that I was reviewing that was attached to my rebuttal related to Mr. Guerin's statement. And that's where, from the prior case, that is similar to what is described in his testimony in this case. And that's to my reference to it.
Okay, let me go there to see what it is.
So if you look at my attachment JJS 1-R, I've asked a question from case number 99644, which is the same relationship and discussion that we're having here. And as is the initial part of response is, this is a misstatement on Mr. Guerin's part. That's the reference that I'm describing.
Right, and then I'm looking at this response from the case, and for the record, case number 9644 is the Columbia gas rate case from last year, from calendar year 2020, correct?
Yes, and it's the same language that we have in this case, and that's why I made the statement.
Right.
And included it in my rebuttal.
Correct. In your rebuttal testimony in this case, you attached a data response that Mr. Guerin sponsored in the last case, 9644, correct?
That's correct. That's the attachment on my rebuttal testimony. When you bring it into context from what's listed in my rebuttal testimony as it refers to Mr. Guerin's position on loans, the references are all the same. And that's why I've emphasized it here in my discussions.
Right, and he says here in this response, the data response from 9644 that's attached to your rebuttal in this case, if you look down, and I'm looking at subpart A, he says that is when what Mr. Guerin intended is to say that one of the primary rationales for use of the SFAS 143 method for regulated utilities is that customer payments for estimated future net salvage represent a loan to the company from ratepayers. Correct?
And that's what his response is after he made the misstatement. And the reason why I had the discussion as my rejoinder is because of the fact that FAS 143 is a valuation method. And so referring to it in this presence is inconsistent with the definition of depreciation, which is the recovery of the full service value over a straight line method. And net salvage is part of the full service value. That's how it's all connected together.
Okay, so just so I'm clear on this, you disagree with the statement from this data response from last year that begins, that I just read, that is what Mr. Guerin intended, that sentence right there, you disagree with that?
I'm disagreeing with his statement referring to net salvage as being a loan.
Okay, so
or
when you're
similar
talking,
to a loan. Excuse me.
Okay, so when you're talking about a misstatement and a correction, you're talking about this clarification that he provided in a data response from the case last year, 9644, correct?
That is the reference that I'm utilizing in discussions related to a loan, which is the same discussion that he's having in this case.
Do, do you agree that the concept of interest on a loan is grounded in the concept of the time value of money?
There is some correlation. Yes, I do think that a loan deals with the time value of money. I don't feel that the component of net salvage within a depreciation rate and an expense is, given the fact that the depreciation rate and expense reduces rate base if you include it without, in a straight line methodology. So that's why there's the difference that I have in what his statements are related to a loan.
But you agree that the net salvage concept and the discount rate is also related to the concept of the time value of money, right?
I think the concept of net salvage as a component of the service value is not dealt with the concept of time value of money. I think that FAS 143 talks about, which is a valuation method, does deal with the time value of money, and that is not considered to be within the uniform system of accounts as an appropriate way to look at straight line depreciation and the recovery of the full value. So that's why my whole point is that FAS 143 was not intended to be a methodology for determining depreciation expense or the net salvage component. So the only thing that, as we have just seen in discussion related to the case back in 2007, when this was first discussed, is the intent was that everybody should pay their fair share and on a real dollar basis. And when you take that into consideration, you take out inflation, which is the 2.5% component that I've presented in the case here this time.
So what you disagree with is you disagree with the analogy. You don't think it's appropriate. That's what you're saying?
Oh, I definitely don't think it's appropriate for what we're dealing with, developing a net salvage component and a depreciation expense, and how straight line depreciation should work and how it should be recovered for regulated utilities.
You also talked to your attorney about the fact that, I'm trying to recall, I don't have the live notes. You said, in discussing the discount rate, you said something like, well, all OPC and staff witnesses have been able to say is the point to what the discount rate was in the first case without any further rationale or something along those lines. Do you recall saying that?
The concept that I was discussing was that in the initial case, it was determined that the commission determined that rate of return was the most reasonable representation of what they wanted to use for FAS 143. And my point being, in that particular instance, when reading FAS 143 and the intent of 143 to remove inflation so that all customers pay their fair share on a straight line basis, they had no opportunity to review the fact that the discount rates that we're discussing in this case are more appropriate when you're reflecting taking out inflation, which so that all customers pay their fair share. And rate of return is not that. It over discounts the value and puts more burden on future ratepayers and is not recovered on a straight line basis and does not recover the full amount in a fashion so that all customers would pay their fair share. So the whole concept of what was determined by the commission in that case to try to develop fair payments for all generations of customers did not have the opportunity to review an appropriate discount rate, and thus in subsequent cases, when discussed either in the District of Columbia or in Maryland, there has always been just follow precedent, and that precedent is rate of return. Well, they didn't have an opportunity to reflect all the appropriate components and what the most appropriate discount rate should be if they wanted to include the proper real dollar component, and that's the discussion that I've described here. And again, supported my testimony with that language. It explains Mr. Majoros's, who's Mr. Guerin's colleague, his position when discussed about this in the District of Columbia, and then also for Mr. Patterson, what Mr. Smith represented in the BGE case, which is again the fact that the discount rate most reasonably is supported or represented by removal of inflation. So those are the things that are kind of the basis for my comments.
The Maryland Public Service Commission has presided over numerous cases where the issue of the SFAS 143 method has been at issue since first adopting it in that case you referred to, from whatever the period was, 12 or 13 years ago, right?
They have reviewed it in subsequent cases since then. And my point being that in the cases that I've been involved in, staff's position has been precedent says rate of return, and OPC's witnesses over, which have been various people, one state that they don't use FAS 143 in any other jurisdiction, and when they come here, they use what's been agreed upon, and that's their basis. You know, not necessarily any support for why rate of return would be appropriate.
But the commission in all of those cases has agreed with those witnesses, correct?
The commission either has agreed with the rate of return, and I'm explaining that all of the issues that were available to them back when that first happened were not presented, and in order to properly agree with what the concept of FAS 143 and its application for regulated utilities. If it was a reasonable way to do it, all of the other jurisdictions would be looking at it as a reasonable option, but they have not. And that's what my point is that I think because in that case 13 years ago, all of the appropriate concepts weren't brought into play when they made their decision, they haven't changed that position because they haven't seen all of the other options. And when I've presented it in other cases here with Columbia, for instance, they haven't seen the reason to make that change. I don't think it's the appropriate way. I'm here to show what is the definition of depreciation and what is the appropriate methodology for doing it. And I believe that the discount rate, if utilized, should reflect inflation based on the language that you see in that Commission Order 1992, which was 13 years ago.
Right, and I think you just acknowledged that you yourself have appeared in many of those cases, and you have provided your opinion as to the universe of factors that the commission should consider, and the commission has never agreed with you on that point, correct?
I agree that they have not moved in that position, and what we have shown, my firm has shown, is particularly in the electric industry that they are now creating regulatory assets because there's not been full recovery of the investment in a timely fashion. So the process is not working. And I'll continue to make that statement in front of the commission, and because it's showing proof. If you look at the other companies, particularly the electric companies, they have not received accrued as much as they're incurring because of the present value approach that is being utilized. The discount rate is too high. It pushes costs off to ratepayers into the future, and the current ratepayers are not paying their fair share. So I am going to continue to express the concept of regulated utilities and the uniform system of accounts and depreciation in hopes to make that clear. But my point from again handling Sir rebuttal from Mr. Guerin is he did understand why I was bringing up a 12-year-old case, and I'm saying that the 12-year-old case in the District of Columbia was more recent than the.
Mr. Spanos, Your Honor, Your
Yeah,
Honor,
you're
Your Honor,
so
this has
tall.
gone way, this answer has gone way beyond the question. The question was just confirming that Mr. Spanos has presented this data to the commission, and the commission has never agreed with him. I gave him, before objecting and interjecting, because I hate to do that, I tried to give him a fair amount of leeway, but this has just gone on way beyond the scope of the question. And
Okay, well, and I think that he's already answered the question a couple times, so you can go ahead. Do you have any other questions?
yes, Your Honor. Mr. Spanos, you work at Gannett Fleming, is that right?
Yes, I do.
And that's a consulting firm?
It's an engineering consulting firm. Yes, all across the U.S. and Canada are primary offices.
How many consultants work at that firm?
There are 2,600 employees as part of Gannett Fleming, if that's what you're asking me.
How many testifying consultants who appear in either regulatory proceedings or civil court proceedings, roughly, work at Gannett Fleming? In other words, people who would provide testimony in an adjudicated proceeding.
Just for depreciation or for all topics of potential cases?
Let's say depreciation.
Depreciation, there are currently 3 testifying witnesses. I think you've probably seen the testimony of my colleague Ned Alice in the state of Maryland.
Thank you. Can I have Your Honor's indulgence a moment?
Yes.
Thank you, Mr. Spanos. Just a follow-up. The 3, are you one of the 3, or it's you plus 3 depreciation?
No, I am one of the 3. Sorry.
So there's 2 others. Ned Alice, who's the other individual?
John Wiedmeyer is another individual that testifies on the topic of depreciation.
Okay. Are you able to state, as you sit here, that you agree with every single statement that either Mr. Alice or Mr. Wiedmeyer has made throughout their careers in testimony?
I agree with the concepts that they have stated. We've been very consistent in following the uniform system of accounts. So I haven't heard every single statement. I've seen all of their testimony, so I've agreed with their testimony. But I have not been involved in every single case where they have been on the stand. But we have practices and standards that we follow, uniform system of accounts, NARUC, and under those guidelines, we've been on the same path throughout.
How many years have you been testifying?
Well, I've been doing depreciation 35 years. I believe I've been testifying for 23 now. I think I have about 380 cases that I've testified in to date.
Mm-hmm. And you don't have any opinions in the world of depreciation that differ in any way from those of your colleagues?
Again, you're asking opinions. we may have differences in a service life that is incorporated or a net salvage percent, but not in any concepts, because we're followed by the guidelines of depreciation. And that's why I feel comfortable knowing that we're all doing the same thing, because the Society of Depreciation Professionals has guidelines to follow and ethics to follow, and we continue to utilize the same concepts: straight line depreciation for utility companies, utilizing the average service life procedure where appropriate, using equal life group procedure where appropriate. Those methodologies are all consistent.
Thank you. Your Honor, may I review my notes for one more minute, please? And thank you. Thank you, Mr. Spanos. No further questions of the witness, Your Honor. Thank you.
Thank you.
Ms. Moore, do you have any follow-up?
No, I do not, Your Honor.
Mr. Spanos,
Your Honor.
I just have one quick question. If you are using the 2.5% inflation rate and the present value method, does that get you closer to results that would be consistent with the straight line method of depreciation?
The methodology is closer to the straight line depreciation using 2.5% and removing inflation, based on the how those calculations are done. So if you use present value with a 2.5% discount rate, it will produce results that are closer to straight line depreciation. It's not exactly the same, but it'll be closer than using rate of return.
Thank you. Are there any other questions in light of my question?
Your Honor, staff, could we do a limited cross-exam, please?
Go ahead.
Mrs. Spanos, Kenneth Albert on behalf of staff. I know you and I have chatted before.
Yes.
This has been an interesting discussion. I mean, we're disagreeing about the original rationale of when the present value method was adopted, and specifically here where what the discount factor, we talked about the universal system of accounts and what insights it offers and accounting standards. I want to shift the focus to the sort of the real world of what's happening here. Negative salvage is included in Columbia's rates many years before Columbia will actually incur salvage costs, correct?
The net salvage component is an end of life component, and the actual incurred cost will be at the end of life, and the overall process of determining what a fair service value is, and again, under the definition, is to anticipate or estimate all costs, including the plant and service, and then depreciate that over a straight line basis. So yes, we are incorporated when the net salvage component includes that, but you also are reducing, again, as I mentioned before, rate base when you incorporate the accrual component. So there is both pieces going forward, and that's the appropriate way to recover that investment, is to develop all your costs and recover that over a straight line method.
Okay, but I'm getting more to the real world. There's a pot of dollars. Typical gas facilities in the last several decades. We're looking at 30, 40, 50 years on a piece of pipe, especially the newer plastic pipes that they're putting in that have a longer service life. I just want to get to the real world. I appreciate the rate base reduction as a rate mechanism, but this is sort of a little different standard here. We're talking about what do we do about that pot of dollars and to reflect the return, what the utility does with that. And you're aware of the fact that Columbia, like most utilities, has a fairly aggressive replacement and upgrade program, which requires a significant amount of capital, correct?
That's correct.
And they've indeed issued a significant amount of debt to ensure they have enough capital for the required upgrades, correct?
Yes.
And they have this pot of dollars. Now, salvage, of course, is a subset of depreciation. So let's call that depreciation and salvage dollars. That's money that's in the account. Again, we just chatted that may be 30 or 40 years before that money has to be paid out. So the utility, as any prudent operator would be, before it goes out and borrows a dollar, it's going to use the dollar that's sitting in its account. In this instance, a dollar that's attributable to the advanced recovery of salvage and depreciation, correct?
I think your isolation of the net salvage component as to how it fits into the entire company plan is a little difficult to respond to in that fashion, because you would not expect customers to take on the burden that did not receive the benefit of those assets while they were in service. So part of the benefit of having pipe in the ground is the fact that its service value includes the end of life component. So trying to isolate one aspect of the service value of an asset because it's at the end of life, and fitting that into how a company puts together their debt plan is a little bit hard to isolate in my world of depreciation.
Okay, I guess really what I was saying was a lot simpler. It's a pot of dollars called depreciation, which includes salvage, that the utility has free use of until it actually has to go out the door. And my only point is a substantial portion of Columbia's costs are capital expenditure costs. So we can assume, and I'm not tracing dollars here, and I'm not asking you to do that either, but we realize that those pot of dollars will go, at least a large portion of that, to the capital expenditures of the utility and upgrading its system, correct?
Well, the company has already expended the initial capital dollars to operate, and then future capital dollars will have, they'll have the ability to make those improvements in order to fit in quality service and reliable service to their customers.
Okay, I'll move on. Have you considered rate treatment are you aware of other settings addressed in a rate case or, in utility rates where there's a prepayment by customers and how that's dealt with in connection with rates?
Not depreciation rates. I'm not following you as far as development of depreciation rates and recovery of the capital investment. I'm not following you as to what you mean by a prepayment.
I'm sorry. Well, for example, I'm thinking of a prepayment for gas. That's an issue in this case. The PGA, when they do it's a PGA issue, and there is a line item in the filings by Columbia that reflects the prepayment by the utility of gas costs, and it earns the rate of return on that. Are you aware of that? That is, I'm sure the utility earns a rate of return on its prepayment of purchase gas costs. Did you consider that in deciding that the prepayment here by customers should not be reflected as with a rate of return applied to it?
The scenario of purchase gas agreement isn't consistent with plant service and net salvage components. There isn't a depreciation component in my study related to purchase gas. So I don't have a correlation between the two to be able to respond in that regard. Again, proper uniform system of accounts says that you pay for your full service value over the life of the service value. It's not dictated by when you spend that money. Obviously, the utility puts up the plant and service component right off the bat, and they utilize those assets. And if they have to retire those assets and incur cost of removal and receive gross salvage, that's a end of life component of that particular asset, and the recovery was during the life of the asset. And that's what why you create survivor curves, to smooth that process out and make sure that all ratepayers are paying their fair share. So I'm struggling to be able to put together how purchase gas agreements affect depreciation expense and the concepts that are required to follow by utility for their assets.
Your Honor, that's all I have. Thank you, Mr. Spanos.
Thank you.
Any redirect?
Can I just have a moment, Your Honor? Okay, just one question for Mr. Spanos. Mr. Spanos, just to recap here, is there a depreciation component or a net salvage component in the company's purchase gas adjustment calculations?
Based on my knowledge of it, not that I'm aware of.
Thank you.
Is that it?
That's it, Your Honor.
Okay. Mr. Spanos, just one other follow-up question. You mentioned earlier staff testimony in a BGE case regarding advocacy of the straight line method over the present value method. When was that case? I believe it was Mr. Smith that you said.
Yes, I'm just looking. It's attached to my rebuttal. It's attachment JJS 1 JJS 1R, I believe. Nope, I'm sorry. Sorry, it's part of my direct testimony, JJS-4, and don't have the date on it. I will have to track down the actual date or and case number and get that back to you. I apologize. I don't have it right in front of me.
Thank you. Thank you. I don't have any other questions for this witness. Thank you, Mr. Spanos.
Thank you.
Your Honor, just to clarify, would you like that as a takeaway?
I can follow up.
Wonderful,
Okay.
thank you.
It's about 12:30. I'm going to suggest that we take a break. Does that conclude witnesses for Columbia?
Yes, for today.
Okay. So I'm going to suggest we take a lunch break right now and then resume at 1:15 with People's Counsel's case. Is that acceptable to the parties?
Yes, Your Honor, thank you.
Okay, thank you. So we can go off the record, Doug, until 1:15.
We're off the record. Thank you.
Thank you.